My client was actually a client of another attorney who was retiring, and he had requested I take over a number of his cases. She came to her original attorney because during a laparoscopic hysterectomy, the doctor stitched off the ureter during the procedure. He didn't recognize that the ureter was tied until several days later when symptoms became pressing. And she ended up with a significant infection in her kidney as well as in her bladder. Their experts kept saying that the ureter was not where it was supposed to be. But they misrecognized the fact that the stitch was actually at the bladder, not at the vaginal cuff. Our issue in the case was not so much that he stitched it off, but he stitched it off in an area where he had no business being, and that is below the standard. I consider their defense to be an anatomical shell game. At one point, they determined or tried to testify to the jury that the ureter was at point A. Then they said it was at point B. Then they said it was at point C. Not really knowing where it was, they continuously shifted around between A, B, and C at the area where they were doing the hysterectomy. The real problem was they stitched off the ureter at the bladder, which was neither point A, B, or C. So it was not an anatomical abnormality. He was in the wrong place. The jury was out for several days on the issue of liability and determined finally, at least by the jurors who would interview with us, that the doctor was trained to do the Da Vinci assisted laparoscopic hysterectomy, and that's what he did, and therefore he could have done nothing wrong. So after getting defensed in trial, it seemed to me that either there was too much confusion, which is pretty much what the jury said, or that there was a complete disconnect between the testimony of the experts and the result in the trial. So ultimately we filed a motion for a new trial and at the same time a motion for a judgment notwithstanding the verdict. He grants the judgment notwithstanding the verdict, in essence finding liability as a matter of law for medical malpractice against the defendant, and then orders a new trial as to the issue of damages. We filed another motion for a protective order to limit the experts to those designated in the original trial. Having won that motion, or at least having the motion found in our favor, the negotiations then become a little more open. And they ultimately did settle. We're happy with the settlement based on the economics of the case. But more important, the client was happy that she had her day in court, that the defendant was not only found to be at fault, but found to be at fault so clearly that the judge made the decision himself, contrary to the verdict of the jury. My client was a wonderful, nice lady. She had to face the trauma of the surgery, face the trauma or the emotionality of being told the doctor didn't do something wrong, and then the roller coaster of finding out that the doctor did, which is what she understood in her heart from the beginning, as did her two attorneys.